Alright, Title 49, Transportation, Subpart B, Subtitle B, Other Regulations Relating to Transportation, Chapter 12, Transportation Security Administration, Department of Homeland Security, Subchapter D, Maritime Surface Transportation Security, and we're on 1572, Credential Security Threat Assessment. 1572, Credentialing and Security Threat Assessment, Subpart A, Procedure for the General Standards. 1572.1 Applicability. Department establishes regulation, credentials, security threat assessment, certain maritime and land transportation works. 1572.3 Scope. This part applies to A, state agency responsible to issue the hazard material endorsements, and B, an applicant who is qualified with a whole commercial driver license under Title 49 CFR Part 383 and 384 is applying with the obtaining renewal and transfer of the hazard material endorsement or obtaining review of the transportation worker identification card according with the Title 33 Part 104, 103, 106, or Title 46 CFR Part 10 commercial driver license in Canada or Mexico is applying for a transportation worker identification card, transport hazard material in accordance with Title 49 CFR 1572-201 or other individuals approved with the TSA. 1572.5, the standards for the security threat assessment, scheme with the TSA for the terms the applicant imposed the security threat and warning denial of hazard material endorsement training work transportation worker identification card if the applicant is disqualified on offensive as described in Title 49 CFR 1572-103. Applicant does not meet the immigration status requirement as described in Title 49 CFR 1572-105. The TSA will conduct the analysis described in Title 49 CFR 1572-107 to determine the applicant posed the credit security threat. B, applicant has educated their lacking mental capacity committed to the mental health facility described in Title 49 CFR 1572-109. Immediate revocation and invalidation. TSA may invalidate with the TWIC the directive of the TSA to revoke the hazard material endorsement immediately with the TSA during security threat assessment, but that the applicant opposed to the immediate threat for the transportation security, the national security, or terrorism. C, the violation of Federal Motor Carrier Safety Administration regulation. Federal Motor Carrier Safety Administration provides that the applicant is disqualified the operating commercial motor vehicle for a specified period if he or she offensive listed with the FMS, the Federal Motor Carrier Safety Administration rules in Title 49 CFR 383.51. Records indicate that the applicant committed with the offense of the would disqualify the applicant with the operating commercial motor vehicle in Title 49 CFR 383.51. TSA will not issue the determination of no security threat until the state of the FMCAS determine that the applicant is not qualified under the section waiver. In accordance with requirement 15.15.7, the applicant may apply for the waiver of the certain threat assessment standards. E, the comparability of the other security threat assessment standards. TSA may determine the security threat assessment conducted with a government agency with comparable to the threat assessment described in this part of the TSA conducts the hazard material endorsement training with a worker indication. Applicants make a comparable determination. TSA will consider if the minimum standing to the security threat assessment, the frequency of the threat assessment, the date of the most recent threat assessment, the bio-threat of the assessment, including biometric identification, biometric credentials. To apply for the comparability determination, the agency seeking determination must constitute the assistant program manager for the federal agency comparability check with the hazmat threat assessment program, Transportation Security Administration, 601 South 12th Street with Arlington, Virginia 205986019. Terrence TSA will notify of the public comparability determinations made. 4. An applicant has completed security threat assessment but determined to be comparable to the section threat assessment described in this profile comply with the enrollment process of the provided biometric information obtained from the TWIC. If the applicant see the unescorted access to secure area of the vessel or facility, the applicant must pay the fee issued with the Title 49 CFR 1572-503 information collection credential issuances. TSA determined the secondary threat assessment with the hazard material endorsement under this profile comparable to security threat assessment with the transportation worker identification card. TSA determined the security threat assessment with the fast card under the free of the security trade program and administered for the U.S. Customs Border Protection comparable to the security threat assessment described in this part. 1572.7 Reserve 1572.9 Applicant information required for the hazard material endorsement security threat assessment. Applicant must apply with the information required within this section form of the TSA when applying to obtain with the renew the hazard material endorsement. Apply with the transfer of the hazard material endorsement from one safety to another. Title 49 CFR 1572.13E. The acceptance provided in 50A through 12 of the through 16. Applicant must provide the following identifying information. 1. Legal name, including first and middle and last, and applicable suffix, any other name used previously, current previous mailing address, currently residential address that differs from the current mailing address, email address available. If the applicant prefers to receive the corresponding notification via email, applications, the state of the date, the birth, the gender, the height, the weight, color, eye color, city, state, county of the birth, the immigration status of the applicant, naturalized citizen, the heir in the United States with the date of the naturalization, 8 alien registration number, the applicable to the state of the applicant, CL number that has the type of the hazard material endorsement cell with the name of the telephone number, last mile number, the draft of the applicant, current employer, applicant, worker, the employer required the hazard endorsement. If the applicant with the current employer, U.S. military service, included in branch of service 11, whether the applicant is obtaining the renewed transfer hazard material endorsement for a waiver and Social Security number, providing Social Security number involuntary. However, the failure to provide it will delay and may prevent completion of the threat assessment. 13, passport information involuntary and by expedited adjunction process, applicant U.S. citizen born abroad. 14, Department of State Consular Board of Rebirth, Board of Information involuntary and may expedite adjunction process of the applicant whose U.S. citizens are born abroad. 15, whether the applicant has previously completed the TSA with the red assessment. If so, for the date of the program for which is completed with the information voluntary may expedite with the adjunction process the applicant completed with the TSA security threat assessment. 16, where the applicant currently holds the federal security clearance, and if it's over the date of the agency with the clearance performing the information voluntary may expedite with the adjunction process of the applicant has completed with the federal security threat assessment. B, the applicant must provide a statement signature of the date signature he or she was convicted of the found with not guilty of the reason for the insanely disqualifying criminal crime listed. Title 49 CFR 1572-103B with the civilian military jurisdiction during the 17 years before the day of the application applying with a waiver that was not released the incarceration civilian military jurisdiction committing disqualifying crime listed in Title 49 CFR 1572-103 during the 5 years before the day of the application is applying with a waiver is not wanted under indictment in civil military jurisdiction for the disqualifying criminal offense identified in Title 49 CFR 1572-103 with applying for the waiver, was not convicted, found guilty by reason of insanely disqualifying criminal offense defined in Title 49 CFR 1572-103A civilian military jurisdiction and applying for a waiver. 5, is not educated, lack of mental capacity committed with the mental health facility involuntary applying for the waiver meets the immigration status requirements of Title 49 CFR 1572-105. 7, has not served the military, if so, for the branch which he or she served to the day of the discharge, the type of the discharge. 8, has been informed of the federal regulations under Title 49 CFR 1572-11 imposing continuing obligation that has material endorsement holder to disclose state he or she is convicted, found not guilty by reason of insanity, disqualifying crime, educated, lacking mental capacity committed with the mental facility. C, the applicant must certify date of receipt following statement. The applicant must certify the date of receipt following statement before signature line. The applicant must certify the following statement. 15, 17, 11. The applicant responsible for the hazard material endorsement, security threat assessment, surrender for the hazard material endorsement, individual disqualified for the holding hazard material endorsement, Title 49 CFR 1572-5C. He should surrender to hazard material licensing in the state with failure to surrender the hazard material endorsement to the statement as result of the immediate revocation, Title 49 CFR 1572-13A. Of the and/or civil continuing responsibility individual holds of the hazard material endorsement from the hazard material as required within paragraph 8, section 24 hours, have an individual and one convicted warranted with under indictment, complaint, or found not guilty of the reason of the insanity civil military jurisdiction disqualifying criminal offense identified in Title 49 CFR 1572-103. Educated is lacking mental capacity committed with the mental health facility described in Title 49 CFR 1572-109. Renouncing or lost U.S. citizen status with lawful permanent residence. 4, violate his or her immigration status issue, removed from the United States. C, submission of fingerprints information has material endorsement. Applicants must submit fingerprints information required in Title 49 CFR 1572-9 in form acceptable with the TSA with notified with the table the applicable apply with the retain renew the as material endorsement procedure outlined in Title 49 CFR 1572-13E with the has endorsement transfers. When submitting fingerprints and information, Title 49 CFR 1572-9 fee, the described in Title 49 CFR 1572-503 must be remitted to the TSA. 1572, 13 state responsible for the issuing of the hazard material endorsement. Each state must revoke with the immediate individual's hazard the HME. If the TSA informed the state of the individual does not meet the same with the security of the harassment of the Title 49 CFR 1572, 5 with the issue of the initial determination threat assessment immediate revocation. A no state may issue the renew the HME with the CDL and if the state with determines with the no threat for security threat with from the TSA. Each state with must notify each individual with the HME and issue with the state. He or she will be subject to the security threat assessment described as part of the application with the renewal of the HME at least 60 days before the expiration of the individual's HME. Notice must inform the individual that he or she initiated the security harassment required with the section of the time after the receipt of the notice no later than 60 days before the expiration date of the individual's HME. See with the state of the HME may extend the expiration date with the HME for the 90 days. TSA with the not determined with the determination for the no security threat final determination threat assessment. Before expiration date, an additional extension must be approved within advance for the TSA. Within 15 days of the receipt of the determination, no security threat final determination threat assessment from the TSA. The state must update with the applicant's permanent record to reflect with the result of security threat assessment issue with the denial of the HME, the new expiration date of the HME, the notification. Commercial driver license information system operated with the result of the security threat assessment revoked with the denial of the applicant's HME with the TSA straight with the state with the final determination of the threat assessment. For applicants who apply with a training for the existing HME for the one state to do another, the second state will not require the applicant to undergo new security threat until the security threat assessment renewal period established for the preceding issuing state. Notice to extend 5-year expires. As stated with the TSA agent conducting enrollment of the security harassment assessment might retain the applicant information required in Title 49 CFR 1572-9 at least once a year in the paper or electronic form. 1572-15 proceed with the HME security threat assessment. Content security threat assessment components completes include fingerprinted based criminal history record check with intelligence related background check final disposition fingerprint background check in order to know background criminal history record check with the following procedures must be completed. The state must notify the applicant he or she will be subject to the threat of the assessment at least 60 days prior to the expiration of HME. The applicant must begin with a security threat no later than 30 days before the day of the expiration of HME. See whether the state elects to collect fingerprints, applicant information. State will collect fingerprints, applicant information required in the Title 49 CFR 1572-9. Provide with the applicant information TSA electronically, otherwise authorized with the TSA. Transmit fingerprints, FBI, criminal justice information services, and the accordance with the FBI and criminal justice information services fingerprint and submission standards. For pertaining signature, as signed the application on the paper to electronic form from 1 year. Provided with the TSA if requested. With the state elected the TSA agent to collect fingerprints, applicant information, TSA provides a copy to sign the application. The state retains to sign the application for the paper to electronic form for 1 year. Provided with the TSA with the requested TFA transmit fingerprints for the FBI criminal justice information service with the FBI criminal justice information service fingerprint and submission stand with the TSA receive the result of the FBI criminal justice information system and educate for the result of the check in accordance with the Title 49 CFR 1572-103 of the applicable Title 49 CFR 1572-107 an intelligence related check. The conducted intelligence related check with the TSA complete with the following. Proceed with the review of the applicant information under the Title 49 CFR 1572-9. Search domestic international governmental databases. Title 49 CFR 1572-105, 107, 109. Educate for resolve the checks in accordance with 1572, 103, 105, 107, 109. Final deposition following completion of the procedure described in paragraph B or C of the section following procedure applies appropriate to the TSA with the determination of threat security threat statement of the applicant and the authorized the whole HME with TSA. The determined the applicant must meet the security threat assessment standards described. Title 49 CFR 1572-5 of the TSA with the determination threat assessment applicant. The TSA with the determined the applicant does not meet the security threat assessment statement that's described. Title 49 CFR 1572-5 of the initial determination threat includes the statement of the TSA determined the applicant posed security threat warranting denial of the HME. The base of the determination through the information how the applicant may appeal the determination described in Title 49 CFR 1515-5, 1515-9, applicable the statement the applicant may truly did not appeal with the TSA determination 60 days of the receipt of the initial determination does not require the extension of the time 60 days receiving the initial determination order with the final appeal with the file and appeal the initial determination become with the final determination security threat assessment. Alright, T3, the TSA with the initial determination threat assessment, immediate revocation over the applicant with the applicant employer with the appropriate to say with the TSA determined the applicant with does not meet the security threat assessment standard for test survived in Title 49, CFR 1572-5 with the MAPO with the imminent threat hazard The imminent threat, transportation, national security of the terrorism, initial determination threat, and immediate revocation include the statement of the TSA of the determined applicant, imposed with the security threat warrant, immediate revocation of HME of the base of the determination. 3. Information how the applicant may appeal the determination in Title 49, 1515.5, and 1515.9F. The applicable the statement of the applicant must with the appeal with the TSA of the determination. 60 days of the receipt of the initial determination, immediate revocation, initial determination, immediate revocation become the final determination of the threat assessment. 4. If the applicant does appeal with the determination threat assessment, initial determination threat assessment, immediate revocation, TSA with the determination threat assessment, the the applicant prefer apply with the HM and the applicant with the property with the applicant appeal with the initial determination result finding with the applicant posed with the security threat. If the applicant appeal with the determination threat assessment, initial determination threat assessment, immediate revocation procedure for the Title 49 CFR 1515.5 and 1515.9 apply. Applicant who did not make certain the standing of the Title 49 CFR 1572, 103, 15, 105, 109 may seek a waiver in accordance with Title 49 CFR 1515.7 and 1572, 17 applicant information required with the TWIC threat and security information assessment. Applicant must supply with the information required with the section acceptable to the TSA when obtaining with the renewing TWIC with the except provided with the A through 12 of the section applicant provide identifying information, legal name including first and middle name, last applicable stuff with the other names due with the previously current, previously mailing address, current resident, if the difference with the current mailing address, email address available. If the applicant wishes to receive the notification, TWIC for the receiver, the retrieve the enrollment center of the V with the telephone rather than email address. Applicant should able to provide a current telephone number, the date of birth, gender, height, weight, hair color, eye color, state, sounding birth, immigration status. 1. If the applicant is a natural citizen of the United States with the date of the naturalization application, presentation of the United States with the visa, the type of the visa, the number, the date of the expires. 3. The applicant commercial driver with a license of Canada does not hold fast card with a Canadian passport. 8. National citizen of the United States with the alien registration number with the number of signs with the applicant with the U.S. Custom Border Protection arrival departure record of 1 I-94. Except that it is provided in described in paragraph 891 section from the region for the applicant with the TWIC including the applicability application. Job description, primary facility, vessel, pairing, time, port, location of the applicant, most likely required for the unexcusable process known if it does not limit the access of the facility, vessel, port. Most stable the TWSI applicant who had a commercial driver license of the Canada and Mexico applying with the TWIC according with the transportation has been material according to the Title 49 CFR 1572-201. Access to the security access area of the facility vessels must explain and respond with the information paragraph 89 in section 10. The name of the telephone number, the address of the applicant, current employer, if the working with an employer required with the TWIC of the applicant, current employee with the U.S. military service will include the branches of the applicant whose current employer does not require possession. TWIC, if it does not have a single employee with a self-employed, must provide the primary available port location. Applicant requires unescorted access if known. Assuming it does not limit the access to the other vessels, facilities, or vessels or ports establishing an eligibility TWIC. If the credentials mariner applying with the becoming a credential mariner proof of the decision required in Title 46, Chapter 1, Chapter B. Security social number to provide with Social Security number to voluntary. However, the failure to provide with a delay may prevent completion of the threat assessment. 13. Passport report number, city assurance, data issuance, data expiration. This information voluntary may expedite adjunction process of the application to our U.S. citizen or board abroad. Department of State Consular report of birth abroad with the information voluntary and expedite with the junction process of the applicant and U.S. citizen board abroad. 15. Whether the applicant has previously completed the FTSA with the right assessment. If so, the day of the program was completed with the information voluntary may expedite the junction process of the application complete with the TSA security threat assessment. 16. Whether the applicant current holds of the federal security clearance. If so, the date when the agency for the clearance to perform the information voluntary expedite with the junction process. Applicants complete with the federal security threat assessment. The application provides a statement that provides signature for the day of the signature. Was committed for the not able to give the reason and saying with the disqualifying crime list for the Title 49 CFR 1517 103B with the civil military justification 17 years before the date of the application for applying with a waiver. It was not released with the incarceration civil military jurisdiction committee with the disqualifying crime list in Title 49 CFR 715 17 103B during the 5 years before the date of the application applying with a waiver that if not warranted for the under the document civil and military jurisdiction disqualification criminal offense of the Title 49 CFR 1572 103 where waiver Was not convicted, not found guilty, reasonably insane with a disqualifying criminal offense with the Title 49 CFR 1572-103A, civil military jurisdiction applying with a waiver. 5, is not a junction, lack of mental capacity committed to the mental health facility faking facility involved voluntary applying with a waiver that meets for the immigration status requirement that's described in Title 49. 1572-105, it has not insured for the military of the branch of his or she served with the date of the discharge of the type of the discharge. 8, has informed the federal regulations of Title 49 CFR 1572-19 and the continuing obligation to TWIC holders with the TSA with he or she was convicted found not guilty of recent insanity, so applying common injunction with lack of mental capacity committed with the mental health facility. Applicants are presented with the obtain and renew the TWIC may submit the biometric information with the identify the verification for the individual cannot provide the biometric. TSI will collect with the alternative biometric identifier. Application must serve with a date the following statement. Statement in writings, and that's E, F, and G. Alright, 15-17-19, applicant responsible to TWI security threat assessment implementation schedule is provided in paragraph B, the applicant must provide the information Title 49 CFR 1572-17 directed by the owner operator. Implementation schedule with certain maritime or applicant withhold maritime or document issued in February 3rd, 2003 on before April 15, 2009, or a merchant mariner license issued with January 13, 2006 before April 2015, 2009 must submit information required in section not requiring undergo security threat assessment described in this part. Friendly TWIC with the TWIC with the Transportation Security Mission or the is an individual disqualified for holding a TWSA Title 49 CFR 1572-5. He or she must surrender the TWIC to the TSA. Failure to surrender the TSA may result immediate revocation under Title 49 CFR 1572-F. The civil penalties continuing responsible individual hold the TWIC to remember the TWIC required in paragraph A, section 24 hours is an individual convicted, wanted under indictment and complaint with a found no guilty with a reason of insanity in civilian military jurisdiction disqualifying criminal offense identified in Title 49 CFR 1572-103. Injunction, lack of mental capacity committed with the mental health facility described in Title 49 CFR 1572-109. Renounce of the loss of a U.S. citizen status with lawful permanent resident violates his or her immigration status of the order and remove of the United States. Submission from the full fingerprints information. TWI applicants must submit fingerprints information required with the Title 49 CFR 1517-17 for the form of the TSA of the same and then renew the TWIC. When submitting fingerprints information, Title 49 CFR 1517 and the fee for the required in Title 49 CFR 1517 503 must be recommended with the TSA. F. Loss and damage to stolen credential. Individual's TWIC is damaged if the TWIC holder loses possession of his or her credential. He must notify the TSA immediately. Alright, 1572-21. Proceed with the TWIC with the security threat assessment. Concept of the security threat assessment. The security threat assessment of the TSI conduct will include fingerprint-based criminal history record check, the intelligent-related check of the final disposition, fingerprint-based check of the following procedure must be collected with a fingerprint-based criminal history record check that consists of the implementation schedule in 1572-19A and B in Title 33 CFR 104, 200, 105, 200, 106, 200. Applicant is notified during enrollment of TSA collect fingerprints applicant information fee required with the Title 49 CFR 1572-17. Transmit fingerprints for the FBI Criminal Justice Information System according with the FBI Criminal Justice Information Fingerprint Justice Admission Standards. Received and educates the result of the check of the FBI's Criminal Justice Information System according to the Title 49 CFR 1572-103. With the Title 49 CFR 1572-107 information intelligent related check. Conduct an intelligent related check with the completion of the following. Proceed with the review of the application information in the Title 49 CFR 1572-17. Search domestic and international governmental database required with the determined applicant meets requirements. Title 49 CFR 1572-105, 107, and 109. Adjunct result of the checks in accordance with Title 49 CFR 1572-103, 105, 107, and 109. Final disposition filing completion procedures described in paragraph B or C with the section following procedures applied with the TSA with the district with the determination of security threat assessment. Applicant with the TSA determine the applicant's security threat assessment standard described in Title 49 CFR 1575. In the case of the mariner, TSA reserves the determination of security threat with the Coast Guard. TSA with the Determination Threat Assessment Act with the TSA with the determination applicant that does not meet the security threat assessment with the Title 49 CFR 1572.5 with the initial threat assessment. Includes a statement of the TSA with the determination applicant, put with the threat warrant, denial with the TWIC, the base of the determination information file with the applicant, and may appeal the determination described in Title 49, 15, 15, 5, 15, 15, 9. It's applicable. Statement the applicant chooses not to appeal with the TSA determination 60 days with the receipt of the initial determination does not recover the extension time of 60 days of the proceed with the determination orders of the appeal. The initial determination can file the determination security threat. TSA with the initial determination threat assessment, immediate revocation of the application employed with the FMC. In this case, of the area applying with the TWI on the Coast Guard with the TSA with the determines the applicant that does not meet with the threat of standard assessment standard with the Title 49 CFR 1575 may pose the imminent security threat. The initial determination threat assessment immediate revocation includes a statement of the TSA determined the applicant posed with the security threat, immediate revocation of the TWIC unescorted acts of the security area with the base of the information on how the applicant may appeal the determination described in Title 49 CFR 1515.5, 1515.9, applicable for a statement of the applicant chooses not to appeal the TSA determination for 60 days after the receipt of the initial determination, immediate revocation, initial determination, immediate revocation become with the final determination threat assessment. 4. If the applicant does not appeal the initial determination threat assessment, initial determination threat assessment, immediate revocation, TSA serve the final determination threat assessment with the FMSC, case of Marine Coast Guard and applicant employers as appropriate. Applicant appeal the determination threat assessment, initial determination threat assessment, immediate revocation procedures. Title 49 CFR 1515.5, 1515.9, app comply. Applicant meet now certain standards. Title 49 CFR 1572, 103, 103, 105, 109. Make the waiver in accordance with Title 49 CFR 1515.70. Or 1572, 23 TWIC expirations. TWIC with the except for the 5 years issue with the calendar date, except for the file with the TWIC issue the base for the determination of applicability with the comparable to threat assessment issue the presume with the comparable to threat assessment TWI expires. 3 for the date with the credential associated with the comparable threat assessment applicant in the lawful immigration status category listed in 115.72, 105.87. Status expired by the employer terminated for the employment of relation with the applicant with the applicant otherwise ceases to work for the employer under any of the circumstances of the TSA deemed the TWIC to have expired regardless of the expiration date phase of the TWIC. The TSA may issue the TWIC with a term less than 5 years to match expiration visa. 1572.24 to 1572.40 reserved.